Good morning, everyone, and welcome to our webinar. I hope you're all there. Unlike in person, I can't see you, so hopefully this is coming across loud and clear. So today our webinar is Piloting Change, and we're going to discuss the Disclosure Pilot Scheme and consider the performance of the scheme so far and the metrics that could be gathered to measure its impact. As a litigation funder, Demonor takes a keen interest in dispute resolution procedure. We have a focus within our business on streamlining process and efficiency. So the original genesis of the pilot scheme were concerns raised back in 2015, I think, by the GC 100, which is the Association of FTSE 100 General Counsel, that the disclosure regime was not cost efficient. Just some housekeeping before we dive in. We will send you a link at the end to access the recording, and you can share that with your colleagues. We'd like to make as much as possible the event interactive, and so if you have any thoughts or comments, you'll see on the right hand side of your screen a chat box where you can post questions or comments there that will be seen by the panel. If you can't see the chat text box, then I think there's a drop down arrow that you can click on to open that section up. If you're as IT literate as me, that might be helpful. So moving on, as you all know, the Disclosure Pilot Scheme is a living pilot, and so feedback and monitoring its performance is essential. We're therefore delighted to be joined by Professor Rachael Mulheron this morning, who is the official monitor of the pilot, as well as Sarah Mkhitaryan, who is a partner at Bryan Cave, Leighton Paisner, and Ben Hamilton, who is head of sales for UK and Europe at Servient, which provides e-discovery solutions, and also my colleague here at Demonor, David Walker, who is our senior legal counsel here in the UK. So we've got a very diverse panel. Before I hand over to them to introduce themselves properly, I should just quickly introduce myself. I'm Emily O'Neill. I'm the General Counsel for the UK for Demonor. I moved into litigation funding last year, having previously been the Chief Counsel for IP and litigation at a FTSE 110 company. So I've managed disclosure in-house, and I'll share my thoughts from that perspective as we go through the session today. So David, let's start with you.
Hello everyone, my name is David Walker and I'm a senior legal counsel at Demonor in London. In my past life in private practice, I was a commercial dispute solicitor focusing on commercial arbitration and investor state cases. I then moved into litigation funding a few years ago, and I worked at another large funder before joining Demonor at the start of this year. At Demonor, I work with Emily and others on sourcing and funding litigation and arbitration cases globally, but with a particular focus on high court litigation and English law arbitrations. And so my interest in this and my focus is very much coming from a third-party funder's perspective and the cost and the time involved in cases.
Great, Rachael.
Good morning, everyone. As Emily said, I'm the official monitor of this pilot, and it was originally, as you know, intended to be a 2-year pilot, but now we're into its 3rd year. My involvement is very much trying to obtain feedback from the legal community as to how it's going. So my purpose is to provide my reports to the Disclosure Working Group. I'm not a member of that, but I provide my reports to them so that they can act on them and consider them and mull them over and so on. So that's very much part of my role as to why I'm here today, in order to obtain feedback from all of the audience. Thank you.
Brilliant. Sarah?
Hi, thanks Emily. Good morning everyone. I'm Sarah Mkhitaryan. I'm a partner in Bryan Cave, Leighton Paisner's commercial litigation team with a focus on complex commercial litigation, banking litigation, high net worth litigation. I've had the good fortune perhaps, we'll see, to have a couple of cases under the pilot and a couple of cases in divisions that aren't involved in the pilot. So I've been able to compare both the sort of former and the potential future regime over the last couple of years.
Perfect. And Ben?
Morning. Thanks, Emily. Morning, everyone. Hi, I'm Ben Hamilton. I'm head of sales UK and Europe for a company called Servient, and we provide e-discovery platforms. I've myself worked in e-discovery and computer forensics for about 11 years now. So all my experiences around getting data organised, searched, and easily reviewable by the lawyers. So, and more now than ever, help with workflows to make things efficient.
Brilliant. So now that you've met everybody, let's get started. And I think we'll start with sort of the initial impressions. And Rachel, I think a good starting place is to recap on where we are today, and given that, like you said, the scheme has been extended until the end of this year, where are we and what are the next steps in this living pilot?
Yes, thank you, Emily. Yes. So as I mentioned in my preface remarks, it's now the 3rd year of the pilot. It was originally intended to be 2 years. In the course of that 2 years, I provided 3 interim reports to the DWG, the Disclosure Working Group. The first was quite early in the pilot in March 2019, and that was looking at the CE file and the court processes and seeing how it was sort of bedding in as far as the court was concerned. So that was a very short report provided to the DWG very early in the pilot, and that one wasn't published because it was really about in-house procedures. The second was quite interesting because the second one was in July 2019, and for that purpose I looked at CE files across the business and property courts, and particularly at the DRDs, and having a look at what models of disclosure were being ordered, what the issues were that were coming up in CMCs and so on. So all of that was anonymized, and then I did some graphs as to the models that were being produced or ordered, and both suggested and then ordered on the part of judges. And it was quite interesting to see the variety of models that were being both proposed and ordered at that time. So that was in July, and again, that one wasn't published because it was provided for the DWG's purposes, and the decision was made for that one not to publish it. But probably by far the most important was the one in February 2020, the 3rd interim report, which I believe is in the chat box as a link. That was produced on the basis that a questionnaire was circulated by me in October 2019. And so people were given the opportunity to give their feedback about how the pilot was going. It was very interesting. It covers 16 sections, and it covers everything from initial disclosure to the burdens of contacting ex-employees, right through the DRD, the models, the division between issues for disclosure and the models for that need to be selected. It was wide-ranging, and that one was published, and no doubt many of you have actually had a chance to read that by now. But at that point, in October 2019, actually 60% of those who responded had done only 1 or 2 cases. And indeed, many of the responses said that it was too early to judge in empirical terms whether or not the pilot was saving money. But what I'd asked at that point were 4 questions about the overall impact of the pilot. One was, has the pilot saved costs as far as respondents were concerned? The second was, had it improved the accuracy of the documents which were being disclosed? Thirdly, did respondents think it had reduced the burdens on the court? And then finally, had the pilot achieved the culture change, which was so important as the motivator for this pilot? Now, it has to be said that, and all of this is summarised in section 15 of the interim report, that indeed the feedback was quite negative at that time. Indeed, 85% of respondents did not think costs had been saved. 42% thought that it was too early to say about the improved accuracy, but 42% said it hadn't. 71% thought the burdens on the courts had been increased, and 78% thought there'd been no culture change at that point as of November 2019. So, of course, we've moved on a lot since those days, and my first task, I think, now is to ascertain whether respondents feel the same way or whether their views have changed about those particular aspects. But the second really important task is to now try and quantify the impact in terms of both time and costs. Now, as I say, the earlier questionnaire was too early in the pilot's process in order to ascertain that with any accuracy, but I'm hoping that it will be possible to get some concrete data, and that's really why I'm here today, to learn and to listen and to see what it might be that is available that could be anonymized, such that I would be able to ask the right questions to various participants, whether they be law firms or e-disclosure providers and whatnot, to see what could be ascertained for the purposes of the DWG. Has the pilot saved costs? Has it increased costs, or has it been neutral in effect? And what the culture change has been? Has it existed or has it not? So that's very much, as an overview, where things are at. The anecdotal impressions of 2019, I think, now have to be buttressed with really, good empirical data. But I've got to know the sort of data that's available and what questions to ask. So in an overview, that's where we are at the moment.
Thank you for that. I mean, one of the reasons we're conducting this webinar today is to try and think about what measurements or metrics could feed into that and what we can, what feedback there could be, what form that should take. We conducted a poll of the participants in advance today, and unfortunately it seems that around 60% or slightly over 60% still haven't had a case that's gone through the pilot the whole way. So perhaps we might still be too early. One thing might be that we might need more time. But Sarah, turning to you, I mean, what's the general impression been from a law firm perspective of the impact of the disclosure pilot and how it's changed litigation so far?
Yeah, I think picking up on where Rachel started, I think practitioners did think that there was a need for some form of cultural change to disclosure. It had got unwieldy, it had got, the size of disclosure in comparison maybe to the sort of quantum of the cases had got quite disproportionate, and people really did need to take a look at what could be done. I think particularly so much over the last sort of 10, 15 years as e-coms, as Ben can come on to talk about, have just exploded. And the idea that you were ending up disclosing, hundreds of thousands of emails or, web chats, all the kind of different communications that we're all familiar with and how we could approach them. And I think from that perspective, I think practitioners really did sort of get on board with the spirit and the objective of the disclosure pilot. I think what perhaps hasn't translated on the cultural side is that it hasn't made it a more consensual process, and it hasn't, I don't think that in practice people are working together to try and resolve issues around disclosure. If anything, and it's made that disclosure discussions and the run-up to the case management conference a bit of a more contentious process than perhaps it was historically, where people were working just under the assumption that standard disclosure was the right way to approach things. I think one thing that also has been quite positive is this idea of initial disclosure, whether that's a natural follow-on from the pre-action protocols and what you might disclose at that stage, or actually as a separate category of disclosure. That has really helped to focus both the client's minds and I think practitioners' minds on what the really important documents are, what the really important issues are, and whether that can lead to an early facilitation of settlement discussions or something similar.
Yeah, I agree with that, because from my point of view, I always saw it as a very positive thing, and I still think it's a positive thing. But as Sarah says, it seems to have caused a little bit more discussion, where actually it's probably, well, it's designed to create less discussion around the data. The discussion should be around the legal points, not around the data itself. The data should be the simple part, really. So I think the aim of it, to get everybody thinking about data is great. I think we just need a little bit more, well, maybe people need more practice with them. As you say, there aren't that many DRDs, well, sorry, there aren't that many people having experienced the pilot from start to finish. From an anecdotal perspective, as an e-discovery provider, when we get asked for help in filling out the DRD, it's great, because we can be a bit more empirical. We can say, okay, look, you need to answer this question in this way. What I've seen in many other regards when I've seen a DRD after the fact, there's a lot of backwards and forwards around very vague descriptions of our email server, our backup server, and not a lot of discussion about what's actually in there. How do you get to it? So the more you look at how to fill in the DRD earlier, the better it's going to be, and less clouding of the issues. That's how we see it anyway.
I think that maybe picks up another concern that you see at a practitioner's end, is that perhaps the pilot has front-loaded some of the costs, and there could be a nervousness in the sort of wrong case to engage someone like Ben to help with, a data mapping exercise or something, looking forward to the DRD, because, perhaps those costs don't need to be incurred at that point of the case, and they could really dissuade the parties from sort of doing that exercise properly.
Yeah, that was always a big concern. Yeah, the front loading of costs is a massive one, really, because and quite rightly so in the past. I mean, front loading of costs was a major problem. I mean, why would you say, okay, fine, let the discovery provider go and do what they want to do. They'll spend £20,000 on it. We'll then give the results to the legal team. The legal team say, okay, I'm not sure about this direction. So of course, front loading is a very legitimate concern. It's not quite so bad these days, because there are different ways that that data can be looked at. But again, I suppose it comes back to the point of just looking into it, just having a discussion around what the data may look like, where it is, how difficult it's going to be to get to it, what aspects of the data can be put to one side and not talked about for, you know, at the beginning stages. So I think, yeah, I think discussions will get rid of the front loading, hopefully. And that's, again, that's what the pilot's for, isn't it? And that's what the DRD should be for, I think.
It's interesting that both your comments about front loading, because many of the responses to the questionnaire said that one of the front loading aspects was that counsel was now much more involved in the CMC than used to be the case, and that this was in and of itself increasing the costs of the pilot at the beginning of the process of the litigation. So I'd be quite interested when looking at the empirical data as to whether that trend has continued or whether that has sort of eased off, and if it has continued, to what extent has that added to costs, or has it ended up being cost neutral? But that is an important point, I think, that it'd be very interesting to get further information on from those who've been through the pilot.
Yeah, I think certainly anecdotally, I would agree that counsel are definitely more involved in that process than they ever were before, you know, which inevitably increases costs, I think.
Mm.
I think just picking up on the front loading point from a sort of in-house perspective and thinking about what's actually happening within the client, you know, so obviously internally there will be a budget for the litigation, and this also sort of comes into the funding and predictability. So within the client, and when I was in-house, I was in an organisation which had some litigation, but you know, our business was selling products, selling boxes. It wasn't litigating, and so we didn't have, you know, a specific litigation team set up in terms of IT, in terms of understanding the different businesses. There were 12 business units. They were all independent of each other. And having to do the process and go through and identify early on actually does create quite a lot of pressure inside the client in terms of time. And then I think the second point is what type of litigation is it that may have come out of an internal investigation where there would already have been some sort of document review, and so in sort of starting that process again so that you have something which, you know, you can attest to in the litigation, and ensuring that the process is complete is also maybe a bit of a duplication at the client. I agree in terms of the cost and involving somebody like Ben early. I think that if there's always a bit of sort of hesitation there, because if you get an e-discovery provider involved early on, particularly at the investigation stage, then that might be unnecessary cost, but then at the same time it saves time, business time later on, so IT time and time in terms of individual custodians in gathering their documents. So I think although sort of from an in-house perspective, I'm not sure that there would be sort of empirical data that could be gathered around that. I think it's still sort of an important consideration for, you know, the whole process to bear in mind.
Mm.
And Rachel, do you have any particular kinds of data sets that you think might be available or that would be particularly useful to you? I mean, are there specific metrics on costs, for instance, that would be useful or more or less useful?
Well, yes. As I say, I'm sort of learning as from these sorts of seminars as to what data would be available. But it seems to me that there's perhaps 6 things that I would just mention as to whether any of these are, you know, possible, feasible, able to be obtained with respect to the pilot cases, those that people have experienced from the beginning of the pilot up to the state that they are now. One is the J codes and the activities underneath J codes as well. Would that sort of information from law firms suitably anonymized, would that show whether when one compares pilot cases to those which are outside the pilot, would it show certain costs being incurred or not being incurred in relation to pilot versus non-pilot cases? Would that sort of data be available, and would it be useful? The second point is the disbursements. As I say, with respect to so many people in the original third interim report in the original questionnaire who said that the counsel's fees were much more noticeable early on, I just wondered whether there was any, in that respect, and any other disbursements, whether that had increased under the pilot because of this front loading that so many respondents talked about, or whether, as I say, that's sort of tailing off or becoming cost neutral. If that information was available, that would be great. The third one is as Emily's mentioned, the in-house technology reviewers that are available, I believe, in many law firms, that they do that work in-house in many law firms. I just wondered if is there any data whereby one can compare a block of months of costs incurred, and that one could take that block versus a block that occurred before 2019? Can we compare post-pilot and pre-pilot figures, or does one have to look at particular cases which are under the pilot versus particular cases pre the pilot? I'm not sure to what extent that data will be possible to obtain, but it seems, as Emily just said, it seems that it's a very important aspect of the cost of disclosure in modern litigation. The fourth is the e-discovery providers. No doubt that Ben will be able to help much more on this, but have the costs incurred with respect to e-discovery provided by external sources, has that increased? Has it decreased? Is it cost neutral? Is it possible to tell the impact that the pilot has had in relation to e-discovery providers and the expenses that that's incurring? And then fifthly and sixthly, I just wanted to try to get a handle on, it's one thing for disclosure to have, whatever the inter-party costs might be in relation to disclosure. That's very interesting. That's the fifth aspect. Have those increased, decreased, or remain much the same? But also quite interested in the own side costs, those which can't be recovered. What is the gap between inter-parties and own side costs? Has the own side costs actually decreased, or have they increased as a result of the pilot? Would it be at all possible to be able to determine that from the data which law firms have? So those are the 6 aspects which I've mulled over, but I haven't got any data, of course, yet, and I'm not even sure if I'm asking the right questions, but that's the sort of thinking that I've got in mind at the moment. I'm very happy to be guided as to any other questions, or whether any of the 6 that I've raised just wouldn't be feasible in the current climate. So I look forward to feedback on that, please.
So Sarah, I guess over to you from the law firm perspective. I mean, are these the right questions? And are these the right kinds of data sets that law firms might be able to help with? I mean, another thing that came out of our poll was about, I think it says 67% of people weren't sure whether there was empirical data available to assess the impact of the pilot. But most people, when they did suggest categories, it was always about time and cost. So what kinds of information on time and cost do law firms have that might be helpful? And also, obviously, there's a bit of a delta between build costs and inter-parties costs, and how can we address that?
Well, I think one place that would be a good place to start is obviously the cost budgeting regime, which has, been in place for a lot longer than the disclosure pilot, and people should have in-house systems for recording costs to set them as against the budget, and then any, perhaps, I guess the delta, as you referred to it, David, between sort of budgeted costs perhaps and own client costs, to see where you are and how your estimating is going. And I think that has to be an excellent source of empirical data, because you must be able to look at budgets that are approved. Are people then having to come back and get, uplifts to budgets or agree variations to budgets as a result of things that have flowed out of the disclosure pilot? If so, are the parties approaching those sorts of uplifts consensually, or is that something that has to go back to the court to be ruled on? Again, I think, we're quite early on, so maybe the really hard empirical data is difficult to sort of look at to compare as between a standard disclosure exercise and an older case or an exercise under the disclosure pilot. But I do think the sort of own side costs have increased. Some of that's, I think, understandable. It's explaining the new process to clients who won't be familiar with how it's going to work, engaging around the DRD and engaging with people like Ben to do data mapping exercises, which inevitably at the minute are perhaps slower exercises that take up a bit more time. And hopefully over the next couple of years and moving forward, as people become more familiar with it, we'll build in efficiencies that will allow us to reduce that delta. I think when looking kind of forwards to budgeting for disclosure as well, it's really critical to involve someone like a Ben to help you map what you've got and to be able to add actual data to what you're talking about. I think you quite commonly used to see witness statements from partners running cases saying we've got 250,000 emails and it will take trainees 100,000 hours to review them, and I think that'll then cost 150,000 pounds to do. And that's not really, I think, what's actually being done on the ground when you come into doing disclosure, particularly if you're using things like technology assisted review, or you're doing under the pilot perhaps issues-based disclosure, which some issues might be being addressed by more senior members of the team and not in that kind of more traditional document review model that perhaps we were all familiar with when we were junior lawyers.
Yeah,
do you think that has changed, that the senior-junior work allocation has changed as a result of the pilot?
I think certainly in the DRD phase it has. I think the input required from senior fee earners on the case is a lot more significant. Looking at things like the list of issues for disclosure, what model might be appropriate, even the consideration of issues around like custodians, date ranges, search terms, which we'll all be familiar with from standard electronic disclosure exercises. That seems to have been become a bit more complicated under the pilot, particularly if people try to carve this up so that different issues for disclosure have different, date range parameters or custodians or search terms.
Do you think that having a sort of a focus on the issues and at different levels earlier on, because of the pilot, has meant that there are additional settlement opportunities, or that the clients are kind of thinking about, their case in a bit of a different way a little bit earlier on, so case resolution might be speeded up by this?
I think the initial disclosures certainly helped with that, because I think one thing you used to historically see in settlement discussions was, well, I want to see and wait and see what the other side have got, and then let's think about settlement. And getting that earlier preview of key documents, I think, has helped facilitate it. But I think that perhaps the DRD process and then looking to issues for disclosure can perhaps then push that the other way to say, well, if there are these categories of documents that we're going to see, and 2 or 3 of them are really, really going to be probative as to liability or as to quantum or whatever it might be, I think a lot of clients are then keen to wait and see what comes out of it before moving forward with settlement.
And then I think one other question is about the impact on the client side in terms of cost. Do you have much visibility on whether your clients, particularly your corporate clients, for instance, are incurring much additional cost up front or in general in dealing with the pilot?
I think, clients are sort of all different categories of clients, and you go from the most sophisticated that have very familiar with internal investigations, regulatory investigations, litigation, and perhaps are very well set up to address some of the rules under the pilot, things like preservation notices and suspending document destruction, all the kind of things that you would see at the sophisticated end. And I think that those clients are the clients that are most appreciative of the intention behind the pilot, because they are the ones that have struggled historically with volume of ecoms, volume of disclosure exercises. As you sort of come down the either size or complexity of the client structure, I think it then flips and it becomes too much of a burden perhaps on the client. If you don't have a dedicated internal IT function, or if it's just one person who's dealing with that, and that's when clients are really looking to have to engage with someone like Ben much earlier to help both with the actual practicalities of it and also, I think, actually the technological understanding.
Yeah.
It's interesting in relation to the feedback and to the first questionnaire about the point of settlement that you've raised, Emily. There was one comment that always struck me, that the only reason our case settled post CMC was that the respective clients saw how much was spent on the CMC process and the DRD, that didn't want to take the matter forward and convened a mediation. And another said that for cases under 250,000, they felt that the costs being incurred were disproportionate, and that there was less incentive to settle then, because once the costs had been sort of incurred with respect to the CMC and the DRD process particularly, then which they called front loading, which had not been necessary under CPR 31, then there was no incentive to settle to the extent that there would have been. So there were quite a few comments about the incentive to settle, and they were both for and against actually in relation to the costs that have been incurred. But I think that's incredibly important, because as some people said, it's there is more to do at the beginning, particularly with respect to the DRD, sorting out the list of issues for trial, the list of issues for disclosure. Often you do need more senior people involved in that, and it is absolutely essential that you sort that out, because the DRD specifically addresses that point. So I would be, really interested in that sort of empirical data, even if some of these cases haven't got further down the track. Those that have got to the DRD stage and the CMC stage, and even if we can look at that particular window, and that would be incredibly useful, I think, for the DWG if that was available.
Yeah, I think just on a side part to that, going back to some of what Sarah was saying as well, one of the problems is that the idea of the front loading and the difficulty of the data mapping and all these sorts of things, I mean, those are absolutely definitely concerns further back, but the way that the market has changed in terms of data storage, not just from an e-discovery perspective, but just from a real world IT usage perspective, the costs have gone down dramatically. And so one of the things that I'm always trying to explain, and this is a lot of the time to the clients, not to the lawyers, because the lawyers do understand this, I say to them that there isn't cost, there isn't this huge cost. We're not doing this massive processing exercise. We're doing a very surgical look, but sometimes that's just discussions. But my view to it all is let the lawyers get eyes on. And there aren't so many barriers to getting eyes on with the data anymore. So if you can let the lawyers get a look at the data, they can run their searches in advance. They can have an idea as to what's good and what's bad about the data, what may be missing, and maybe try and bring the volume of the exercise further down. So if you let the lawyers get eyes on early, they can do so much more. And of course, then that follows on to being able to talk to Emily and funders to be able to say, right, okay, we've got a great idea as to what we've got here, what it's going to cost us to do, how long it's going to take. And that may not be good for Emily in the sense that might help Sarah to be able to tell the client to settle earlier. but getting lawyers' eyes on, I think, is not difficult, but it's perceived to be.
I think that's a point as well that was changing even prior to the pilot. I think particularly on the big commercial cases, people were doing that data mapping exercise, and they were coming to the CMC with an idea about what sort of data sets they'd be looking at, search terms, partly I think driven by the funded cases as well, because that's the sort of information that it seems that funders are looking for when trying to understand what they're looking at for a disclosure exercise.
I think there's, just picking up on Ben's point, I think there's two parts to the sort of eyes on early. With my sort of in-house hat on, I think having your external legal team having eyes on early in my head says more cost. And earlier costs, and then trying to manage a budget when you've planned internally, because within an organization there's not just the sort of the legal impact of the case, but you're also talking to your finance team, and there's a real sort of financial modeling. You're looking at your results by quarter, by half year, and if something happens a month earlier, that could pull the cost into a completely different sort of financial accounting period, which could have a real impact on that particular part of the business. So I think there's sort of mixed views in terms of the eyes on early, but I agree in terms of knowing what you have and identifying who's there. That's something I always, who the custodians are, where they are, where the data is something I always did early on, because until you sort of know, you have a vague idea of what the shape of your case is and what could be out there, that's quite difficult then to manage internally. So I agree that having that as part of the process is probably something which the client may have already thought about, particularly if they have an in-house litigation counsel and already have sort of progressed quite a long way before the discussions with the lawyers. I think from a funding perspective and sort of driving the sort of behaviour, our risk analysis is a little bit different, and I've had to transition my sort of risk analysis from an in-house perspective to a funding perspective around funding a case, because we are then taking over the risk at quite an early stage usually in terms of the case. So I think it's positive that people are sort of thinking and looking at the risk earlier, and if the funding process is helping that, that's obviously a good thing. I think moving back to the data itself and the types of data, how available is the data? because I think one thing that I've experienced when I've been looking at data and trying to pull metrics and draw conclusions before is things might be recorded, but how easy is it, or will it be for law firms to extract the data in a meaningful way and in an anonymized way? And also, you know, the e-discovery providers. I used to use our own e-discovery provider and a separate law firm for the disputes I ran. So I think to get an overall view for a particular case, you might need data from sort of two sides. How easy would it be to extract and report on that data? And do you think that there will be the sort of willingness within law firms and e-discovery providers to actually spend the time to do that exercise to build into this living pilot? Maybe Ben, I'll start with you.
Yeah, exactly. So, well, from an e-discovery provider perspective, we get to see lots of different cases. We don't really understand, the full rationale behind the cases, but we see the different styles of cases, the different types of data that come in, the volumes. We also see, how quickly, we're involved, or how late we're involved, which obviously causes all sorts of trouble. So, from our perspective, I mean, we can give all sorts of numbers as to what's a sensible and proportionate amount of data to be looking at. Obviously, different cases have different amounts of data. But we've done cases with litigation funders where we've done it on an at-risk basis for that exact reason, that there's a lot of cases that are kind of in limbo. So there's a good case, there's good discussions around it, the lawyers are happy to put it forward to the funder, but there isn't the lawyers are happy to put some time and effort behind it to investigate the case and get it ready for funding. But there might be what is perceived to be a mountain of data in the background. So what we say, well, just give us the data, we'll get it ready, we'll let the lawyers get eyes on, they can then do a better assessment, a proper early data assessment, perhaps more than an early case assessment. And then, that's that information that goes forward and helps everybody. So from an e-discovery perspective, I think I'd be talking for most of my competitors and colleagues when I say that, we're very happy to do that initial look, those initial discussions, because otherwise we all end up talking for weeks and weeks on end, and we still don't get to where we need to help everybody fill in the DRD and then to go forward. So that's a long explanation, but from an e-discovery perspective, yes, we're very happy to help.
Yeah, and from a law firm perspective, I think that data, it must be there. It has to be there. We're all capturing, we're all billing our clients, frankly. So we are capturing the time that is being spent on this work. And so it shouldn't be impossible for us to be able to extract, anonymize, quantify in the right sort of way data to provide to Rachael and the disclosure working group so that they can get a much more data-driven feel for how things are working in practice. I think, the cost lawyers must be a good source of this information. Those specialists that really deal with kind of budgeting and assessment after the event, they should also be able to give a good insight into what's there, and hopefully should be able to provide more information that you can build on. And I mean, I can't see why a law firm would have any objections to that. Ultimately, we're trying to estimate accurately for our clients or for our funders or for both as well. So it's in all the parties' interests to make sure that we're doing that process properly, efficiently and accurately.
I think one of the things also to bear in mind is that, of course, the pilot, PD51, you brought in some new concepts, and as initial disclosure, you've mentioned, Sarah, as well, but there were some wrinkles to begin with that have been ironed out now, haven't there? I mean, there was a dispute about the when and to disclose known adverse documents. There were issues about the burdens about the preservation duties with respect to ex-employees, and there have been certain changes that have been made to PD51U in order to take account of some of the concerns that were raised, particularly those that responded to the questionnaire. I mean, that really was taken on board, that feedback, and also the DRD itself has been streamlined in response to some of the concerns that people had about just how complex it was to fill in. So I suppose that some of the costs that have been incurred to date, I suppose, would be regarded as dead costs now, because those sort of issues have been clarified, and I'm conscious that will also be difficult to extract from the general disclosure process, which has been required for just working out what documents the other side has. So I think that it is important to bear that in mind. Some of these wrinkles are being sorted out and have been resolved, and it will be, in that respect, more straightforward in those particular aspects. So I realise it's quite a daunting task for law firms particularly to draw this out, and maybe they won't be able to separate that issue or those issues that they may have had concerns about with adverse known documents, for example. They may not be able to sort of hive off those costs from the general costs that have been incurred in relation to disclosure on case A, whatever it might be. But I would I'd be very grateful for that sort of feedback, because I'm conscious that when people responded to the questionnaire in 2019, it did take time. I was very conscious of the fact that law firms had given up their time to do it, but it did have a big impact. It really did. The DWG took account of the concerns that had been expressed about particular aspects, and amendments were made. So I just mentioned that is the this is not going to go into a vacuum by any stretch. So I think the investment of time that law firms and others can make in relation to providing this data, it will be taken note of, I'm sure of it.
Yeah, and I think you're giving your email out later, Rachel. So without at risk of flooding your inbox, I mean, I can send anecdotal, but anybody that's listening in on this call, if even if it was a case before the pilot, if you've got a good handle on, what the costs were perceived to be at the beginning of the case and what they ended up being later on, then fire into Rachel. Sorry, Rachel.
By all means.
I think just sort of moving on from there. So I think the purpose of the pilot scheme was to really drive the cultural change. And I think we've touched on a little bit in terms of initial disclosure and thinking about things earlier and maybe settlement, different views around settlement. But what have the panel sort of seen around behavioural cultural change, views around disclosure, interactivity between parties, and just the general approach to the process? I know I've had experience of US style discovery, and that sometimes has been quite all-consuming in the sort of in-house sphere, where I've had to image everything that moves with the e-discovery provider, spending weeks of time in a room with people's laptops and phones and servers and things like that. So I think a positive cultural change and a sensible attitude to disclosure is in everyone's interest. But what kind of things are you seeing? And then I guess again, how is that really measurable? Is the time and cost going to be a measure of that cultural change, or are there other things which Rachel could sort of take into account or look at to measure that?
Shall I go first on that? I think I touched on it at the start, and I think that people do recognise there needs to be a cultural change and are broadly on board with the ethos, but I think in practice maybe that hasn't actually been how things have played out. I think certainly the discussions around the DRD have become quite contentious, and that document has become quite a difficult document to agree, both on a practical sense, and some of this was picked up in the third report for the DWG about things like, in reality, how do you file a single joint document in litigation when parties are necessarily not going to have agreed on everything that needs to be in that document? And then on a more sort of perhaps objective or outcome-based approach, there are still a lot of things I think that will be outstanding by the time you come to the CMC, where that document is ready to be used as a roadmap for discussions around disclosure and ultimately orders that are going to be made. And so I think in practice, what we're seeing is parties really digging their heels in on certain aspects of the DRD, whether it's an issue for disclosure, whether it's a scope of a search, or whether it's the appropriate model. It is leading parties to take those positions, I think, and leave those open to the court rather than resolving them consensually together.
Ben, what have you seen?
Yeah, so from our perspective, and whilst I'd still like to see more of it, from our perspective, we're seeing a lot more conversations around the use of additional tech. So technology-assisted review, machine learning, whatever you want to call it. It's just a tool in the arsenal to get the data down to a more manageable size, to do more of a prioritised review. And prior to the pilot, there was always there were discussions around the use of newer technologies. The DRD makes it very, very distinct. It makes it very obvious towards the end of the document that you should almost be having to explain why you're not using some of these more technical features. And again, I think that's right, because if you can think of a good reason why you're not using it, then perfect, that's great. Then you can park that part of the discussion. So I would say that we're seeing more and more people asking us about, do I need to apply technology-assisted review? And for the most part, I'm saying yes, you do. You should try it. It's not always moving forward, but there are sensible discussions being had. Someone comes to us and says, I really want to use this technology-assisted review. I want to fill in this in the DRD. And we say, okay, how many documents have you got? We have a discussion. They say, oh, we've got 18,000. And we say, it won't work. You won't get the benefit from it. But well done for thinking of it. So there's definitely, that sounds patronising, but didn't mean to. But basically, yeah, the cultural shift I see is that more people are asking about technological advances that may help.
I think that cultural shift is also replicated with the judiciary as well. They are very keen to push technology-assisted review. They are very open to make those orders. And if perhaps one party wants to use something like that and the other party is opposing it, I have found in my cases that the judiciary are very happy to go with the technology-assisted review as the sort of almost becoming the default option, I think, for really significant disclosure exercises now. And that is a definite benefit to both parties and the courts.
And I suppose one of the outcomes too is that what the pilot was trying to do is move away from Model D as a standard across these cases. And so in that respect, that if there is more adoption of models other than Model D, then that is also a cultural change, isn't it? Which is what the motivation of the pilot was. I mean, if we have more issues-based disclosure, or if we have less extensive disclosure and less expensive disclosure, then that was something that was being sought. So I guess that would be also of interest to update on the second interim report, which did show a real move away from Model D, whether that is continuing. Of course, if Model D is becoming more predominant as the pilot's going on, then you wonder what it's achieving that Part 31 wasn't sort of doing anyway. But I think that's also, isn't it, part of the cultural change that was being sought, a more variety of disclosure. I mean, it was always there, wasn't it, the menu of disclosure options, but generally speaking, standard disclosure was adopted. So and I suppose just one other point about the cultural change, I just go back again to these lower value claims. Is the cultural change that is being sought there, is it worth the cost or is it not? Many of the respondents to the first questionnaire said that for those lower value claims, particularly the preparation of the DRD was causing just too much disproportionate cost up front. And I know there was some discussion, wasn't there, as to whether, well, some suggested that those lower value claims should be excised from the pilot altogether, and that's mentioned in the third interim report. So I would be interested as to what respondents think about that, about the possibility of lower value claims being removed, or if the costs are too disproportionate for those particular claims. That would be of interest.
Thank you. I think we're going to wrap up shortly, but Rachel, just before we do, is there a next step in the pilot? Are you still in a listening mode? But what's next?
Yes, well, certainly this task of trying to ascertain what the section 15 of the third interim report, whether that can be extrapolated by data, that's a very important point, I think, going forward. The other point, which I think will hopefully be the subject of an interim report too, is feedback from the judiciary. I previously had prepared a questionnaire for the judiciary, but it wasn't the appropriate time to circulate it because the changes to PD 51U were going through the CPRC, and it was thought important to have those go through because there might well be changes that the judiciary then saw in their CMC discussions with parties. So that questionnaire will be going out to the judges quite shortly, I hope. And so those are the two immediate tasks as far as I see it, trying to get the data and also feedback from the judiciary. I think as part of the obtaining data, I think once again, people would be most welcome to give their comments about how they're finding the pilot. I mean, the anecdotal impressions are still very important to the DWG, but I do think we have to try to hone in on the costs, whether they're being saved as a result of the pilot. That's so so intrinsic to why the pilot came into being. So it'd be nice to think that was happening if it is.
Great. I think let's just have a look and see if we have any questions. I think we're coming to the end of our slot now. Let me just have a look in the chat box. So we have one question. What data would change minds? So I guess thinking about, and I guess this feeds back into the technology assisted review and different sort of behaviours which are being driven by use of the pilot. But I guess for those practitioners who potentially have found it difficult or not helpful, what data could help them to sort of engage or improve their experience of the pilot, and what could be fed back into the pilot to, you know, to make this, you know, really a positive experience and a useful experience for litigators?
I think that if we get the sort of data that Rachel's talking about doing, and it shows that in cases that are concluded, it's cost X, and that is 20, 30, 40% cheaper than the same exercise would have cost under standard disclosure, that's obviously going to be something that really does drive people towards both the kind of cultural change and also just taking a more proactive approach to disclosure, which I think is also an aspect of the pilot that it's trying to push, is, you know, approach this as something that you should tackle, get your hands around and really understand, rather than, you know, deal with piecemeal as the case progresses and as things come up. And I think, you know, stepping back perhaps from the disclosure pilot as well, but when you look at the reforms that have been passed in the cost budgeting regime, you know, the upcoming reforms around witness statements and things like that, it's clear that kind of the civil litigation process is going through a period of reform, and all of these reforms tied together should lead to greater efficiencies, cost savings, easier resolution of cases, hopefully.
And would you say, Sarah, that the fact that you think it's more contentious inevitably drives up costs? Do you think that we have to lose that contentious nature of the DRD, try to get more cooperative attitude? Does one follow the other, that contentiousness does increase costs, or does that not necessarily follow in practice?
Is this something to be terrible about my profession, perhaps, here? I don't know. I think the reality is that when issues are contentious, the costs do increase, and that's because parties are less willing to give ground or less willing to perhaps take a view. And I think particularly in the really heavy commercial cases, you know, the cases that Emily and David are funding, and the cases that we're working on at the real sort of top end of the courts in terms of both quantum and complexity, CMCs are really significant undertakings nowadays. They're not half-day hearings, you know, they are a couple of day hearings, they have leading counsel involved, and that's not just on disclosure, that's on all the issues that are being sort of ventilated and decided at the CMC. And I think that in those cases, the CMC has become a real turning point for whether a case will or won't settle. And because the disclosure costs are inevitably incurred, or the pilot disclosure costs are inevitably incurred prior to that CMC, I'm not sure that for those sorts of cases, there will be a real easy way to avoid those costs.
Ben, did you have any last comments around the changes?
Not especially. It just all falls back into the, you know, where we were talking just there. So where Sarah was just talking about the combativeness of sometimes of the CMCs. My final point on it, I guess, would be one of the conversations I had with a partner recently, and we were talking about, you know, what can you do? How forearmed can you be? You know, walking into the CMC. You know, can you do that with the DRD? Can you do that prior to filling in anything? And I said, well, look, you know, this is how you would do it. This is the information you can glean. This will tell you how much data you might be looking at. It'll also give you an idea on how much data the other parties might be looking at. So, you know, if you know that they've got 10 times as much data as you, and you've worked out that you've got 100,000 documents to look at, then, you know, you've got an idea of the scale of their problem. But the takeaway point from his was, look, I just don't want to be walking into the room when the other side have got this information. So that was, you know, that's my takeaway point.
Great. Well, I think they were all the questions. So it's just left for me to say thank you to our panel. I think that's been a really interesting and useful discussion. And part of the purpose of today's webinar was to draw out the different metrics that could be available to support Rachel in her role as the official monitor. So following the session today, we'll circulate contact details of the panel. When you're submitting your thoughts to Rachel, make sure that, as she said, that they're in a case anonymised format, so that they can be fed into the pilot and taken into account as that moves forward. And so thank you very much from me. We have reached the end of today. We have another webinar coming up on the 22nd of March, which will look at risk analysis in litigation and how to model risk. So we hope to see you then. Any other comments or suggestions, please do share them with myself or the other panelists, and have a lovely day. Thanks very much.
Thank
Bye.
you, Emily. Bye-bye.
Bye.
Bye-bye.